I, Brother Thomas, people hereby decree this court of record, where the law of the case is common law, into session, and we're going to start with proceedings now.
As reasonable people in South Africa, it would make sense that we have a trust in our leaders, those that are elected to guide and lead us, those that are elected and asked to guide and lead our judiciary, those that are chosen to head up education and health. It would be reasonable of us to trust and to believe that they were presenting us with the best option. And when they share with us, for example, that the only option that we have is to vote in an election as we have coming, or that the only option that we have is to submit ourselves to a magistrate or a high court, and they do not include or declare that there are alternatives. When we listen to our health department saying which way we must go, and there is no mention made of the wisdom and the healing practices that show evidence of wonderful healing, and those practices are erased from the options that we have a breach of trust. It is from this point as a breach of trust in our government and the knowledge that government is corporatized, that we say that this is not a political position, but a real life position of real living people that seek health and happiness, peace and freedom. And it's this evidence that we bring to you today, on which you will together with us vote as to whether we need an investigation to bring up specifics.
I see this as a movement that ultimately seeks to make the kingdoms of this world the kingdom of God. Not just in hymns and prayers, but in reality. Because if our faith doesn't shift into action, then it is actually just a performance.
We are claiming, and I'm sure we can prove in a commission of inquiry, that every single transaction right now in South Africa, from SARS to traffic department to the courts, is all fraudulent, because we do not know what we are signing. So not only do we have the laws for creating money, which is called the Bills of Exchange Act, which they use, but they do not allow us to use it, and they withhold that information from us. So this would truly liberate the people. If we win this case or this gets brought before a commission of inquiry, and all the facts are found to be true, then there would be no more poverty, because you would be able to finance any social or environmental restitution project, and this is what is sorely needed on this planet. We need to simplify a law that everybody can comprehend it. It needs to be as simple as possible. I mean, justice is that everybody can find remedy, and today we have had no remedy from the court, so there is no justice. We have proven in this constitutional court there is no justice. So we need to seek justice ourselves. We put these people in those positions. They are public servants, okay? And this is what we need to determine in a commission of inquiry, is, are we a democracy where the government is sovereign and they control us through citizenship, or are we a republic, like the Bill of Rights says, and the land and everything belongs to the people and we are equal shareholders? We need to determine this. And the courts have to provide remedy. That is justice. They have given us no remedy, no rights, no reasons. So the Constitutional Court of South Africa has basically said, we do not uphold the Bill of Rights. And this is what we need to question, because that's our only freedom. We fought. People fought for the Freedom Charter from 1955. And we fought for the Bill of Rights. People died for this Constitution. So we can't let it slide. And this is what this interim hearing is about.
For the record and on the record, I, Jan of the family Lofeld, a people, and appointed interim public prosecutor for the people, from the people. As we've just established, there's three aspects: the constitutional aspect, the judiciary aspect, and the financial aspect, which we're going to detail. We'll be bringing evidence forth, which will be discussed here today. I would like to, first of all, for the procedure, we have filed and served a writ of mandamus, which is a common law order or request to anyone who's wearing a government badge to come forward and to represent themselves or a delegation to come out here today. I've got a list here with 80 people who have all served, who've all been served, they've all received the document. And as far as I know, only one single lady from the Department of Communication. She was here earlier on.
She was here earlier.
So we have got that on record. Okay, I'm going to proceed in terms of the judiciary. What like Brother Thomas pointed out, we have various cases taken to the High Court levels where we have been seeking justice, remedy, and in all cases it was utterly denied. The justice system has failed. We have filed various documents, common law documents. We sat in the courts, we had members of the grand jury present in various stages of the proceedings, observing the proceedings to document the fraudulent activities in the high courts. We requested, in all cases, we have requested a true bill or the original wet ink document. And this is addressing the financial sector in particular, where all these documents have gone missing miraculously, and every single man and woman who has asked for them, even in sworn-in affidavits. I've got 3 sworn-in affidavits where the bank states under oath that they cannot locate such document at the time. That's a complete breach of the Bills of Exchange Act, where 2 parties sign a contract, have a right to view that contract at any given time. So then we decided there's a breach of constitutional rights. So we then set forth and said, okay, we are filing with the Constitutional Court, because now we have a strong breach of Bill of Rights, of access of information, access to the courts. So we took it a step further and said, let's file with the Constitutional Court. Let's write a good, solid founding affidavit where we would put in all these breaches of constitutional rights. We also addressed all the remedies that goes with it, and have filed the case on the 3rd of February. We have then also allocated all individual cases as supporting documents in an annexure. That was filed. The Constitutional Court initially gave us 10 days. They would say they would respond to us within 10 days. They didn't, so we kind of seen it as a consent by silence. And then after 20 days, they then decided they send us a one-liner fax where it said no prospect of success. We have then also seen, because in our case, which was the Unified Common Law Grand Jury versus the Republic of South Africa Pty Ltd, including all the agents, also including all the judges of the Constitutional Court. So they were the defendants. But now they acted outside the court because the defendants themselves made a decision that they are not going to have this case heard. Because we were told by the Constitutional Court, by Marty Stander, the Chief Registrar, if we make the judges of the courts defendants, then the President himself needs to establish another tribunal, another group of judges who would oversee the case, because the judges themselves are now the accused, the defendants. The judges then made the decision outside the court, and they said the case has been dismissed, which I think to all of us has been a clear statement of an admission of guilt, because they obviously could not have the matter heard inside the court. It is a huge case, maybe even the biggest case in history, which would have probably revealed all the doings and wrongdoings of SARS, the Treasury, the Presidency, and any other agency involved in the entire apparatus. So we have seen in various cases there's no remedy in the high courts.
The court is the suit of the sovereign. We are the suit of the sovereign as equals and as peers. And so this is a lawful court, and it is above that court. As much as that court is the supreme law of the land, we, the people, have instituted that court. That court wasn't instituted by those people. We, the people, instituted that court. And we, the people, can demand justice, and we will get justice. So that is where the confusion comes in this country. We are forming a body so that we can ensure that if people are starting to use common law out there, that it's procedurally fair. And if anyone has a complaint out there, they can make a complaint to us, and we can call a jury together or assist them and give them advice. We have had a few cases already where there have been disputes between people, and this process has helped them to resolve it, that they don't have to go to a commercial court. So we just have to start using it. And so we're going to shortly ask you if you have any more questions to ask, and then we're going to decide, should we take this matter further? Do you people feel that there's a need to investigate this more for a commission of inquiry, or are we just mad?
I think also, just to quickly read out from the Bill of Rights, is the access to the courts. Number 34. Everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or, where appropriate, another independent and impartial tribunal or forum.
It's us.
Here we are. This is the impartial independent forum.
Tribunal. So I call on you people, we need a unanimous decision here if we are going to proceed to call for a commission of inquiry so that this can be investigated.
Over the last months, we have gathered 10,000 names of people who have acknowledged that their lives are not getting better, and they are putting their names to a memorandum of a vote of no confidence. We have shown common law jurisdiction. We have shown evidence of the court systems working as if they were representing banks. We have shown evidence of a lack or reason for lack of trust in our government and our leaders. Is this evidence sufficient for you to decide and agree that a commission of inquiry is necessary?
So we're going to stand together and we're going to cast a vote. Anybody, those who are in favor of continuing this action, please raise your hand. For the record, every single man and woman here has raised their hands, and we will adjourn the court now. We've now convened the court, adjourned it. It's been nice for anybody who wants to say something, please come and speak and let your voice be heard.
Ngicela ukuthetha isiXhosa because ngifuna into yobana abantu bave into yobana umthetho awukho ngasecaleni lethu. and ungekho nje awuzusimela noba singaba noba ungaba nengxaki akekho umuntu ongama ecansi kwakho because umthetho usebenzela i-corporate. And bendicela into yobana abantu abasivayo isiXhosa banimamele njengangoku ngoba apho siyakhona siyohlukunyezwa apho siyakhona. Ngoku bendicela into yobana abantu bavule amehlo bethuna niyibone indima yokuthi ningenelele njengomphakathi njengabahlali balapha eSouth Africa, niyibone indlela ugovernment asiphethe ngayo uba ayikho ntle. Njengoba senivile ke ndicela into yobana wonke umuntu onesikhalazo esithile aze ngaphambili kwi-common law uzobeka izikhalazo zakho ngale ndlela ofuna into yobana umameleke ngayo. Ndiyabulela.
We are the people of this country. We got now, we struggle for a lot of years to get our right as a people. So there's no other way. See that we must look back but to move forward. I call on all of us. Don't be afraid. Say what you want to say. Do what you want to do. Pray with it.
So we are divided, and we're an extremely divided species. But there's only one planet. So we've got to make it. There's not a plan B or planet B where we can go to. It's there. This is it. So we've got to make it here.
Thank you, brothers and sisters, for your hearts and your time and your minds and your will. And we will continue the process. And we ask that you share the thoughts and the ideas and the movements and the procedures and the evidence. Yeah.